Senator Weber, welcome to the committee. This is Senate File 141, and we do have a quorum present.
Mr. Chairman, members of the committee, thank you for the opportunity for me to be able to be before you and present this bipartisan bill, Senate File 141. Relatively short bill, but in essence what it really does is exempts our municipals and REAs from having actions brought to the PUC concerning their purposes. I think as a result of what we have seen in our communities, having served 16 years as a councilman and mayor and running a municipal electric business within our city, having seen my co-ops in action, I think that we have to recognize that, quite frankly, they are responsible to the ultimate authority, and that is their customer, because their customers elect them, elect the board of directors, elect city councils and mayors, and as a result, that made me comfortable in bringing this bill forward. The one thing that I do wish to comment on is that this bill in no way, shape, or form changes net metering rules and regulations as they exist, and nor is it intended to. And I think at this point in time, so that we may have efficient use of our 15 minutes, I am going to turn it over to Jim Horan at this point, and please introduce yourself for the committee.
Mr. Horan, welcome to the committee.
Thank you, Mr. Chair. Jim Horan from the Minnesota Rural Electric Association, representing the state's 45 distribution co-ops and 6 generation and transmission co-ops. I wanted to start out by telling you what this legislation isn't and then explain what this legislation will do. As Senator Weber mentioned, this legislation makes no changes to net metering and will have no impact on solar in Minnesota. Cooperatives will continue to follow the law as they have since their creation by local communities over 80 years ago. This makes no changes to the grid access charge, which is authorized by the legislature in 2015, and that has very specific requirements in statute. Those specific requirements limit the size, scope, and variability of that charge. The uniform formula developed by the cooperatives goes even further, taking into account the impact of the specific DG facility and not charging anything on the first 3.5 kW of installed distributed generation. The grid access charge, again not changed in this legislation, was implemented by the cooperatives and clearly meets the statutory requirements and will be collected regardless of this legislation. This legislation has nothing to do with net metering. It merely clarifies a section of statute, bringing it in line with what the rest of the utility statute does as it applies to the relationship between the Public Utilities Commission and local democratically regulated utilities. I'd like to provide a quick example of what this legislation would do in practice. Let's say a member doesn't like an interconnection charge at a cooperative. The responsibility for the interconnection cost, the charge, along with what can and cannot be included in those costs, is clearly stated in statute. The member who doesn't like the cost goes to the cooperative. The cooperative provides an accounting and rationale for that cost. Now, if the member still doesn't like the cost, one of two things happens. If the member believes the cooperative is violating the law and they can't resolve the issue through the cooperative's dispute resolution process, the member can request the Attorney General's office intercede. This is the same as under current law. The PUC cannot take legal action against a violation of the law. Now, if the member thinks the cooperative should socialize some of the legally recoverable interconnection costs, and the member can't convince the regulatory board to place his interests above all others at the cooperative, the member should rely on the democratic process, and that's what this bill is about. Working to convince his fellow members that certain costs should be socialized and paid for by all members regardless of how they use the system. This process has worked well for cooperatives and municipals for over 80 years and should continue to apply here. Cooperative boards, as democratically elected regulators, are constantly striving to put members' interests first. However, putting members' interests first doesn't mean giving every member exactly what they want. The democratically elected regulatory board balance the interests of all member owners of the cooperative. The current statute needlessly asks the Public Utilities Commission to balance again the same interests that have been locally regulated within the law. That duplicative regulation is unnecessary, costly for member owners, and only serves to second-guess their local decisions when providing no benefit. Please support this modest request for regulatory reform and continue to put your trust in local decisions for local communities. Thank you.
Thank you, Mr. Horan. Members, we're going to go through the remaining 2 testifiers. If we have additional time in the 15 minutes allotted for Senator Weber, we'll ask questions at that time, as well as in the remaining time after the opposition has their moments or their time on in front of the panel. Next is Linda Laylat. Sorry, I'm bad with names today. Laytala.
Laitala.
Please, welcome to the committee. Please provide your testimony.
Thank you. Mr. Chair, members of the committee, my name is Linda Laitala. I'm elected director of East Central Energy Cooperative. ECE is located in Braham, Minnesota, and serves over 59,000 members, all the way from the northern suburbs of the Twin Cities up to the outskirts of Duluth and into the rural areas surrounding Superior, Wisconsin. Directors of East Central Energy are elected for 4 years. And while we are responsible for the member owners of our cooperative, I represent a district within that of nearly 9,000 members, 8,970 to be exact. As an elected director, I have a fiduciary responsibility to our cooperative to ensure that we provide the essential services, that to balance the interests of the members fairly, and that we collect the costs needed to operate the utility. We support and promote clean energy. We work closely with members who purchase wind turbines and solar panels to ensure that they are safely installed and grid ready. To date, our members have interconnected 53 solar and 14 wind turbines with our system. We also offer members the ability to purchase cow power or electricity generated from methane gas, which we purchased from a farm near Princeton, Minnesota. Last year, we held our first ever EV evening, an electric vehicle demonstration in Braham. We had electric vehicles from 5 different manufacturers at that event. Lots of questions, lots of members. Electric vehicle ownership in our territory is growing, and ECE has responded with multiple EV rates that are tailored to meet individuals' needs. We also have a staff of 4 working with business owners every day to help them operate in a more energy-efficient manner. We offer rebates for commercial members for energy-saving projects such as lighting, HVAC, motors, and drives. In addition, we offer low-interest gap financing loans for economic growth in our area. ECE encourages our employees to be involved in their communities, and we invest in area youth by offering scholarships from funds derived from unclaimed capital credits. In the 10 years that I've been a director, we've averaged $60,000 a year in scholarships. As an elected director, I'm directly responsible to my member owners. I know many of the owners by name and in my district personally, and I hear from them regularly with their questions, their comments, their concerns, and their complaints dealing with the business of our cooperative. ECE regularly surveys our member owners, asking a range of questions dealing with rates, power supply, programs, and service options. And then we share these results with our members through our locally produced at ECE newsletter, The Advantage. We have a website that lets members know about the new programs and of outages in their area. We're on Facebook and Twitter. We have an annual meeting open to all members. Our CEO encourages questions and comments from members in an open forum. In addition, we have 4 annual customer service events every year, spread throughout our service territory. This is to show our members that we appreciate their business and we want to hear what they have to say. The constant focus on member feedback and member engagement is because we are member-owned. Our members drive every decision we make. The current regulatory process is unnecessary and only adds costs to me and to my fellow member owners in time and money. Please support the local democracy legislation and continue to allow member-owned cooperatives to make member-focused decisions. Thank you.
Thank you, Ms. Litala. We have approximately 6 minutes remaining in this time. Next is Deb Erickson.
Okay.
Welcome to the committee.
Thank you. Mr. Chair, members of the committee, thank you for allowing me this opportunity. My name is Deb Erickson, and I'm an elected member of Minnesota Valley Electric Cooperative located in Jordan, Minnesota. As an elected director, I've represented Minnesota Valley for over 7 years. There are 45 distribution cooperatives in Minnesota, and we are similar, and yet we are all different. We provide affordable electricity, and we all are locally regulated through a democratically elected board. The size and demographics of our cooperatives vary greatly, from rural agricultural areas of the state to the lakes and then the metro region. No two cooperatives are the same. It is through our local regulatory process that we balance the needs and wants of our member owners within the law. Our right to be locally regulated enables each cooperative to provide their member owners the energy programs that are desired for their cooperative. Whether it be a community solar garden, energy efficiency program such as demand response or load management, or perhaps a community solar project. Now, as a democratically elected director, a member of a member-owned cooperative, I appreciate and I understand the role of the Public Utilities Commission. I follow their meetings and I respect their opinions and decisions. Their role is necessary in working with the investor-owned utilities and the delicate balance between the ratepayer and the investor. However, with a member-owned cooperative, the ratepayer and the investor are one and the same, and I am one of them. You see, this is why the cooperative business model works. It places the interest of our members first. We have a system of checks and balances. When differences of opinion arise, our process ensures that those interests are heard. As directors, we are available to our members. If they have an issue or a concern, they are able to contact us directly, and they do. We listen, and they are allowed to advocate their position on anything impacting them. All requests are listened to. In addition, any member can run for our board. This ultimately gives the power to the members to determine the future of the cooperative. This is how cooperatives have ran for over 80 years. I, along with my fellow directors, take our regulatory role serious. We focus on being responsive to our members' interests and needs. At Minnesota Valley, we focus on providing energy information and innovative programs to our members. We provide our members access to daily electric usage information on their bill. We provide all our members access to daily and hourly electric usage information via our website and a smartphone app. Our members can then use that information to determine which actions they would like to take and what MVEC programs they can participate in to optimize energy usage. With over a dozen programs, our members have a vast array of options to choose from in managing their energy profile. Over 40% of our members participate in such a program. This seems to be meeting or exceeding our member needs. I think this is really interesting to note. Our cooperative consistently scores 89% on the American Customer Satisfaction Index. By comparison, the average investor-owned utility scores a 72. We are innovative, we are responsive, we are locally regulated. The cooperative business model works. Please eliminate this unnecessary duplicative bill.
Thank you, Ms. Erickson. We have about 2 minutes remaining in this portion. Are there any questions for these testifiers that we could take right now? Senator St. John.
Thank you, Mr. Chair. Just to the board members, do you have any just recollection of complaints or disputes that individual members would have brought to your board? Just a couple. I just want to get a sense of what kind of complaints members might have.
Probably best for,
Okay, I can answer that.
Top.
We've had questions on rates, complaints on rates, and as a result, we have changed some of our rates to make them more fair. We've also had questions on time of service.
Got time for one additional question. Anyone on the panel? Okay, hearing none, we will take the opposition individuals. We have 15 minutes, again, allotted for that group. I'm going to call up, at the chair's prerogative, some on the list here, some interesting, to get a dynamic of different viewpoints rather than having all farmers show up like farmers, but in this particular case, we need to have a lot of other perspectives. Glenn Jacobson, an attorney from Sacred Heart. Jim Nichols, a farmer from Lake Benton. And Sam Villa, I'm really lousy, he's with Connexus Co-op. He's a member of Connexus Co-op. Okay. With that, we will start with Mr. Jacobson. Please welcome to the committee, and please state your name for the record.
Glenn Jacobson, and to correct the agenda, it's spelled with an E. I'm an attorney. My farm is near Bird Island in Renville County. I work for the county as a county prosecutor. I have a wind turbine that I've had for 9 years. I'm scheduled to install 19.5 kilowatts of solar this spring. As an attorney, as a prosecutor, as an ordained minister, and as an Eagle Scout, I'm as trustworthy a person as you can find in this room. I am subject in everything I do to review and oversight by the court I practice in, by the Court of Appeals, by the Minnesota Supreme Court, and beyond that to the United States Supreme Court. I see no reason why my rural electric cooperative cannot also be subject to review and oversight by the Minnesota PUC. If they are, in fact, acting in my best interest in making fair and appropriate judgments as far as rates and fees, then that will be borne out by a hearing at the PUC. What they are proposing to do is to remove my ability to ask for an independent review and to submit for a decision by the board of the electric cooperative, who are the same people that made the decisions to impose the fees in the first place. And I want that review process left intact.
Thank you, Mr. Jacobson. Mr. Nichols, state your name for the record.
Can I have a page hand this out, Mr. Chairman?
Paige, can you hand out the written document?
Thank you, Mr. Chairman. I'll talk fast. I know
Thank you.
we're on a short schedule here. The very first page that you will see is a page out of our contract with Xcel Energy, and we're generating power for 3.35 cents. On the next page, and that's locked for 25 years. On the next page, you will see that, and the next two pages, I'm paying 17 cents, 14 cents, 16 cents to my local REA. Now, I have met with my local board several times. I've discussed this several times. I'm also the chief author, when I served here, of legislation that removed the REA co-ops from the PUC. That was in 1978. A lot of things have changed since then, and I'll talk about that very quickly. Doesn't work as well as it used to, but they're good people, and I especially like our chair, Sandy Luneman. The Luneman family is a great family, and you all know Cal, and I've known them for all these many years, and a very good farm family, and we've all farmed out together and had good success for many years. But back to the problem that we have. In my discussions with my board, they have pretty much adamantly refused to purchase any wind energy locally in Minnesota. Basin Electric does have 2 wind farms in South Dakota, but the cost, as you can see there on that second page, if you have it in front of them, they're paying 6 cents per kilowatt hour to buy coal in North Dakota, and the price gone up. I just got another price increase, and I want to send my January bill to you, Mr. Chairman. And they have refused to buy wind energy in Minnesota. Now, it's created thousands of jobs in Minnesota. We generate, I'm a county commissioner. My county alone receives $1 million in property tax payments, which I think you should consider when you pass this property tax bill, because those of us counties, and there are 10 of us that receive a lot of income from the turbines, and I did help write that law when I was a member of the Senate Tax Committee. So it's been the best thing that's ever happened to us out there in southwest Minnesota. And now I know they're going to tell you that this costs them so much money for these payments that they have to make. We have only 13 farmers in Lincoln County that use alternative energy, and the total payment to them is $6,255. If you're concerned about payments when you can buy wind for half the price, why would you not address the $3.6 million that we're now paying to buy coal, and we pay our manager $185,000 a year? And that's fine. My point is that this $6,000, and they've used this many times, that it's costing them so much money. That's just not true. And Mr. Chairman, there's a good next one about is a very good comment by Representative Joe Schomacher, who is my representative, and Senator Weber's my senator, because he's been very good on this issue. And as he said there, we need to support wind energy development in Minnesota. And we certainly do, Mr. Chairman. And for some reason, my REA co-op refuses to do that. And that's the problem that we have. They are free from oversight. And by law, I have to buy my energy from my REA co-op. I would love to use the energy that I generate for 3.3 cents, but I have to go to my co-op and pay 17 to 16 cents per kilowatt hour. And it's going up, Mr. Chairman. And then finally, we're right now building, we've got a lot of wind energy in southwest Minnesota. Right now, project that's going up right now, the north end of the Lincoln County where I live, they're going to create 200 temporary construction jobs. It'll generate $425,000 in local spending, motels, food, a little bit of beer once in a while. It'll generate $24 million in payments to farmers over the next 20 years and $17 million in tax payments. It also creates 12 permanent jobs. We now have 15 jobs in the county, Mr. Chairman. They're all permanent jobs and good jobs, thanks to wind.
Thank you, Mr. Nichols. Next up, Sam, pronounce the last name. I'm lousy today.
That's okay. Sam Villela. Thank you, Senators, for allowing me to testify today. I am a Conexus Energy member owner. In 2009, I put 9 kilowatts of solar PV on my roof. I did that as a hedge against future rate hikes. At that time, electricity was about 8 cents a kilowatt hour. Since that time, we've gone up about 50%. We're at 12 cents a kilowatt hour and change. Out of the blue, in 2014, Conexus started charging me a monthly, what they called net metering fee, which I thought was not legal at the time. In 2015, the law came specifically allowing such a fee, but they've been charging me that before this law change happened. I thought this is a clear violation of the law. I currently have a rate case pending at the PUC. It's docket 15-755, and I'm hoping for, satisfaction in that reason. I certainly attempted to go to the cooperative, and they were not. There's nowhere. It is what it is. They had it set their way. I'm also here to speak that at least my cooperative is not as democratically run as everyone thinks it is. In the elections, only 7% of the people actually vote. I ran in 2 consecutive terms unsuccessfully to try to get on my board. The only people that are elected to the board are incumbents, and they are designated so on the ballot. When someone leaves for whatever reason, usually death, basically they appoint somebody from the public at large, and then that person runs as an incumbent. So it doesn't really happen that somebody just decides, I'm going to run for the board and gets elected. At least in my memory there, no one has ever been elected that's not a non-incumbent, or that is not an incumbent. Also, the rate cases that have gone before the PUC, there's been 3 recently in the last couple of years, have all come with decisive victories in favor of the complainant and against the cooperatives. And, the testimony is riveting, and if you watch the PUC, I would encourage everyone to watch the video. You can go to the PUC site and look them up. The 3 cases were Alan Miller versus Peoples, Larry Fagan versus Minnesota Valley, and Keith Weber versus Meeker. This removes a key oversight. I don't have say in who I get my power from. It's a monopoly. And the only recourse that I have for a disagreement right now is with the PUC, and you're taking that away. I don't see that as favorable for the consumer. Thank you for your time.
Thank you, Mr. Villela. We will call up 3 additional testifiers right now. We have about 7 minutes left in this segment. We will go with Logan O'Grady with Clean Energy, Michael Allen with All-Star Solar, and Alan Gleckner from Fresh Energy. And we'll start with Logan O'Grady. Please state your name for the record and welcome to the committee.
Thank you, Mr. Chair. Good afternoon, members. For the record, I am Logan O'Grady, Director of Policy and Public Affairs at Clean Energy Economy, Minnesota. We're an industry-led nonprofit organization dedicated to strengthening and growing Minnesota's clean energy business ecosystem. We represent and work with industry to educate the public and decision makers on the business case for clean energy and how strong public policies have had and can continue to have positive, lasting impacts on our state's economy. Today, we have brought just a few of the hundreds of solar businesses from all over the state that employ thousands of hardworking Minnesotans in good-paying jobs. The homegrown businesses you'll hear from today would be negatively impacted by this proposed legislation. I hope, Mr. Chair and members, that after hearing their stories, you will be as inspired as I have become by their entrepreneurial spirits, their innovative leadership, and most importantly, their dedication to their employees. I urge you to continue the tradition of support you have for them as we work to build a flourishing clean energy economy here in Minnesota. And with that, Mr. Chair, I'll get out of the way so you can hear directly from them.
Thank you. Next up, Alan Gleckner, Fresh Energy. Please state your name for the record and proceed with your testimony. Welcome to the committee.
Thank you, Mr. Chairman. Members of the committee, have a handout too for the page. It's a list of the current cooperative fees that are in place against solar and wind customers right now in front of the PUC. This comes from an MREA filing. Thank you for giving me the chance to testify today here. I'm Alan Gleckner, the Director of Energy Markets for Fresh Energy, an independent nonprofit that provides in-depth research and analysis of energy issues in Minnesota. While the bill language itself may seem tame, this bill would have a significant negative impact on property owners across greater Minnesota. In essence, this bill is an attempt to allow co-ops free rein to charge a small set of their customers new fees as high as $83 a month. For some context, and as some of you may remember, the co-ops were here in 2015, passing a bill at the very last second of session that authorized them to charge limited fees on customers who exercised the right to generate their own electricity. A key piece of this 2015 legislation was that it included boundaries on any fees. Most importantly, that they are reasonable and based on the co-op's cost of service study. However, since then, 20 co-ops have proposed what amount to the highest fees on these customers in the country, as high as $83 per month. Moreover, the fees are not based on actual cost of service studies, use an inaccurate method to calculate the fees, and include absolutely zero accounting for the benefits brought to the electric system when customers invest in solar and wind systems that offset expensive electricity investments that the co-ops would otherwise need to make. The Public Utilities Commission is reviewing these new fees to make sure they're fair and consistent with the co-op's own 2015 law at the request of co-op customers who have invested their own money on their own property for homegrown energy. Now the co-ops are back here again, this time to prevent their customers from having independent review of these fees or of any future co-op action regarding customer-owned electricity generation in the future. The very fact that the co-ops have proposed exorbitant fees that ignore their own legislation demonstrates why their customers need this last resort for neutral expert review. And the co-ops know that their fees won't stand up to independent review, and so that's why they're here today to make sure that a fair review doesn't happen. Many co-op customers tried to work with their co-op's management and boards for a reasonable solution and have been almost universally shut out. After investing thousands of dollars into their own property and supporting energy businesses in greater Minnesota, we feel co-op customers have the right to question fees up to $83 a month and have them reviewed by someone other than the co-ops themselves. Simply put, if co-ops are allowed to design and run the only dispute resolution opportunities for customers, the legislature will have removed basic safeguards that protect customers and protect the freedom to generate their own electricity. Again, while this language here may seem benign, this is a classic case of the fox wanting to guard the henhouse. Rural Minnesota utility customers deserve better than that, and you should stand up for them by opposing this bill.
Thank you, Mr. Gleckner. We have about 2 minutes left. Mr. Allen with All-Star Solar, please, or another representative.
Chair, members of the committee, my name is Marty Morrood, owner of True North Solar in Edina, Minnesota. This bill is about price, competition, and consumer choice. We've seen solar installations costs go down 40% in the last 6 years. That's driven a lot of interest of Minnesotans wanting to go with this new technology. But now we're facing a time where we're unfairly able to compete that technology against others because of the uncertainty in these fees and solar taxes coming along. How do we have a fair market, open market, level playing field with that much uncertainty in the future? That leaves zero opportunity for the customers to make a fair choice. They have a right to that choice, and they cannot make it fairly without understanding and being made aware of these taxes and fees in the future. Thank you.
Thank you, sir. We are at the app. We got about 30 seconds. If you could make it that. Sorry to be that quick, but we're trying to get.
Thank you, Mr. Chairman and members. My name is Michael Allen. I'm with All Energy Solar, based here in St. Paul. I'm going to make some pretty quick points here. The PUC asked co-ops and munis, how many solar systems they've installed as of September 1st, 2016, and that number was approximately 900 systems. Of those 900 systems, 170 of those are working with our company. We have a very good understanding, that's approximately 20%. We have a very good understanding as to what's going on with municipalities and with co-ops right now, and we have an enormous amount of complaints. To date, we have over 25% of our co-op and muni clients have voiced a variety of complaints, and I think it's important to point out a couple of them, if you give me just a moment. First one, we submitted an interconnection application over a year ago. We've had 3 city council meetings, and we still have gotten nowhere. Our intention is to file with the PUC. We have another utility in northern Minnesota near Duluth that told us that we couldn't install solar panels unless our customer installed a full battery system, and that was going to increase the customer's expense by over $15,000. I'm not going to go into the third. By voting to approve House File 141, you'd be making a poor business decision. You'd be ignoring your clients' issues and stripping them of any rights that they have to a fair resolution of conflict. Instead of avoiding these issues by just eliminating your constituents' opportunity to a fair hearing, we must face them directly. Let's come to a fair conclusion on how to have solar and all utilities work together so that we can move on and continue to build a stronger Minnesota economy. Thank you.
Thank you, Mr. Allen. The time's expired for the opposition. We're going to bring this to the committee itself and have some questions here. Then if there are any amendments, we can entertain them. Before we start, I did have one question for, I think Mr. Horan can answer this one. There was a fee bandied about, up to $83 fee. Can you explain a little bit more about that large fee being imposed?
Sure, Mr. Chair, members of the committee. I'm a regulatory attorney by training, so I can go into great detail on how we've gone into meeting the statutory language that was passed in 2015. But the short answer on that one is the $83 charge comes from a co-op that has a fixed charge, the fixed charge being the cost to serve that member before they buy or sell a kilowatt hour of $98. So $98 is what that utility needs to recover to keep the lights on. The $98 pays for the poles and wires. Their delivery charge, their monthly delivery charge is $15. So the $83 is the difference between the two of those. And so they're only collecting $15. They're collecting the rest of it in the variable rate through a variety of rate designs. But that $83 is a cap, and the $83 would only apply to large-scale systems. We're not talking about the average rooftop system. We're talking about a 40 kW pad-mounted ground system, a larger system, would only apply to that size of a system. And again, it really is going to be dependent on that individual co-op and how they react to it. But the average, we ran this for the numbers across the state for co-ops, the average dollar amount on this charge, on this grid access charge, was $3.10 a month. So not $83, $3.10 a month, and well within the law. And I'm happy to go into excruciating detail with you on the cost of service studies and everything else that went in. We spent months and months with rate experts working on that to put that in place.
Thank you, Mr. Horan. And for other testifiers that were on the list that did not testify before the committee, you're encouraged to have written testimony added to this record. You can certainly send that to my office or to my committee administrator, and we can certainly have that included. Questions or amendments from the committee? Senator Marty?
Thank you, Mr. Chair. Not an amendment, but I guess I have some real concerns about when this bill came in a couple of years ago. We did not have discussion of it. I don't know that there was much in the House, and there wasn't here. Not much of this, and it was meant to be, and the law says, I think it's reasonable and appropriate charges. And I guess my concern is, yes, they're saying one of the board members was saying they're democratically elected, but even the corporation has minority shareholder rights. You can't say, well, because we're in charge, we can unfairly stack the deck against certain shareholders, in this case, certain members. And I guess I have real concern that in this case, because it's a monopoly business, that we are basically saying nobody, in effect saying the complaints have to be resolved through the co-op. It does strike me as they are the judge, the jury, everybody else. They're the ones setting the rules, and they're the ones determining if the rules are fair. And I guess I have real concern, Sarah Weber, about the idea that we're taking away this. I mean, it was required to be reasonable and appropriate charges, and here, who determines it? The co-op board. I guess that strikes me as a good way to put out of business a lot of these small installers. I don't know how many there are. I don't know how many are making money of it, but obviously we've had a lot of them come here wanting to testify. That's my concern.
Senator Weber?
Oh, thank you, Mr. Chairman, Senator Marty. I think that in listening to the description that Mr. Haran gave as relates to the charge in question, there has been a system and formula that has been developed, and I think that in that scenario, there are guidelines. There are definite guidelines to be followed, and I think earlier comment that Mr. Haran had made, if there is a disagreement and concern regarding the final decision, they are also able to call the Attorney General's office and file a complaint there.
Additional comments and questions? Senator Hoffman.
Thank you, Mr. Chair, and thank you, Senator Weber. I appreciate the conversation that Senator Marty raises, and that's the kind of the crux of what I talked to you about prior to this, was that there is still some concerns regarding the alternative dispute resolution, or in this case, the dispute resolution, and some of the assurances that are there. And so I guess the question goes to you and to Jim, is there any leeway or any ability for you guys to go back to some of the concerns that came out under the dispute resolution process within here? Because, yeah, we can file a complaint with the Attorney General's office, but then there's a timing issue on that. And I'm wondering if are you willing to sit down with folks and have a little deeper conversation about, if there's a win-win within the alternative dispute resolution process, and if so, how about can we do that?
For Mr. Haran.
Mr. Chair, Senator Hoffman, yes, we would be. I'd be happy to look at that. My question, and I think I've talked to a few of you about this, we have this kind of two-prong approach. Either you have an issue because you think the utility isn't following the law, and in that case, the Public Utilities Commission doesn't offer you the solution. Only the Attorney General's office can take legal action. If you don't like the decision, the balancing that co-op board has done, the co-op board's authority is actually slightly broader than the PUC's authority in this case. The PUC can't balance any more interest than the local board can. So how to do that without getting into this issue of duplicative regulation or unnecessary regulation where you don't like the local balancing, so you take it to, you forum shop to a different court and you ask them to take a different take on it that isn't going to be as local. The decision within the law is going to be the same. The same issues are going to be balanced. You can't look anywhere outside of it, but you're asking a different court to look at it, and that's the issue we've got, because that has been abused in the past. But I'm happy to be open to sitting down and talking about it always.
Senator Hoffman.
Thank you, Mr. Chair, and thank you, Mr. Horn, for that, for being willing to sit down and do. You might want to, in the spirit of Father Fabian, you might want to bring that Venn diagram and figure that one out. But I appreciate your willingness to sit down and talk to folks. So with that, I just want to say thank you, Mr. Chair.
Senator Dibble.
Thank you, Mr. Chair. In the interest of time, I won't repeat the concerns articulated by Senator Marty and Senator Hoffman. I share those. I would just ask Senator Weber a couple of things. One is, given the testimony that was offered by the opponents about the nature of those who succeed at getting elected to the co-op boards, is that a concern you share? It's something I've been aware of for quite some time. And Mr. Haran talks a lot about the balanced interest and how fair and democratic, yet the only people who seem to get elected are those who are already picked by management. I know a number of folks who have tried to get onto co-op boards and have not succeeded. So there's clearly something wrong with the elections process. So that's one question. I have a second.
Senator Weber.
Mr. Chairman and Senator Dibble, at the same time, I know individuals in my home area who have been defeated as they sought re-election to the board of directors. So it does happen. Is there a proverbial benefit to incumbency? I imagine we've had that debate as relates to judicial elections in Minnesota, and we can even talk about our own seats in that regard as to what benefits are there. But like I say, I do know that in the case of local co-ops in my particular area, I do know individuals who have been defeated in their effort to seek re-election.
Follow-up, Senator Dibble?
Well, Mr. Chair, I think a few too many incumbents were defeated to our body last year.
Well, Senator, I don't know if I agree with that one, but
thank you. Well, I think it's an issue worth examining and worth analyzing. Did Senator Jungbauer run for the Connexus board?
you got,
Did
you
he
got
get
me,
on?
but
Yeah. Anyways, then the second is, of course, we saw the hookup charge or the maintenance fee. Some of these are quite extraordinary. And so, I'm curious about the nature of the design of the ongoing fees, for folks who want to have distributed energy at their homes, and, particularly with respect to solar. Wondering, do co-ops as a rule, I hear a lot about the cost and the burden and the hassle and et cetera, and maintaining reliability, et cetera. So a lot of the downside, but I don't hear a lot from the co-ops about the upside of solar, the benefits, the proverbial value of solar, capacity, economic development, environmental values, reliability and resilience, and as a hedge for future fuel costs and the like. How much of that is factored into this?
Senator Weber.
Mr. Chairman, Senator Dibble, before I turn the microphone over to Mr. Haran, I will mention that there are definitely sites in rural Minnesota where you have large livestock producers that have put solar panels out to utilize for their own needs, and with the excess going on into the system then. And so, there certainly are instances where that is being done. And as far as on a statewide basis, I would need to defer to Mr. Haran in that regard.
Thank you, Mr. Weber. I'd just also like to state that we need to stay to the bill itself. It does not specifically have an indicator that this has to do with solar. It has to do with the regulatory authority that the cooperatives have. So I do want to somewhat stay focused if we can. I know that there's bleed over, but just to stay to the bill. Mr. Haran.
Mr. Chair, Senator Dibble, I'd be happy to talk offline and actually with anybody to go through the detail on what we went into this cost recovery charge. Co-ops, about 2/3 of our co-ops in the state have community solar gardens. There's a lot of interest in the value of it on the system, a lot of investigation into that side of it. We're working closely with our members, obviously, to see what the members want on it, but we're also seeing, as you mentioned, about the resiliency and reliability of solar on the system. So we're investigating it. The cost recovery charge is really that. It's focused on cost recovery. And so we looked at that. We looked at the value of solar, and I'd be happy to talk more with you about that offline to keep it in time.
Thank you, Mr. Haran. Senator Simonson.
Thank you, Mr. Chair. And my comments are going to be a little bit about more about process, and I'll keep them very brief. And I have a whole another list of questions and things that we could talk about the actual content of the bill. But as I listened to the testimony today, and I think we've all had visitors over the last couple of weeks coming to our offices and talking, on both sides of this bill, quite frankly. And one of the things that I'm reminded of as we're trying to hurry up and get to the end here. And I admit I did come from the other body, so I'm just working on getting broken now. But
we forgive that. We forgive you for that,
right.
Senator.
But this hastiness of trying to pass this bill, I just wonder about that. And so my question's for you, Mr. Chair. We had a list here of about 17 or 18 folks that had signed up to testify, and you heard a number of those, and we appreciate that. And I think I heard you give the opportunity for those that had signed up to submit perhaps written testimony to the committee, and we'd see that, which I think we all appreciate. But I think from the public's perspective is about transparency of government, right? I mean, there's one thing to say we can look around the room here and we can count votes and we can see where this bill is going to go, but it's a whole other thing when we say, you know what, we're just going to run out of time here. We're not going to be able to take the public testimony. And when I look at this list, Mr. Chair, members, I mean, there are small business owners on this list, there are farmers on this list. A lot of these folks are just, average citizens that want to weigh in, and I personally would like to hear their testimony. But in the absence of that, in the absence of that, Mr. Chair, because we are going to take written testimony, I think is what I heard you say, I'm wondering if you would be so kind as to consider laying this bill over or tabling it, and let us take the time to absorb some of this testimony that's going to be provided. Just today, we had a few testifiers that handed out a number of materials that I haven't had the chance to look at. And I just wonder, in the terms of transparency, if you would consider that.
Thank you, Senator Simonson. I think I would entertain coming back later this evening. Actually, Senator Weber's committee meets in the next 5 minutes in this chamber. I'm not sure, Senator Weber, if you have an agenda, if you're actually meeting today. If you're not, we suddenly have the room.
Mr. Chair, we actually are having a hearing today in our committee as relates to the Palmer amaranth invasive weed issue in Minnesota agriculture.
Senator, do you have a time estimate on how long you think you would be using the chamber?
Well, we anticipate our normal time going from 3 to 4:30.
Okay. Senator Rosen.
Thank you, Mr. Chair. And there is a pension commission tonight, so I will be unavailable. I do know, does this bill go anyplace else besides this committee?
Senator Rosen, yes. This bill also will, or this next stop for this bill is in finance. So I think there is additional opportunity for testimony to be taken there. And I think the sample that I took from the list here is fairly representative. There may be additional comments that individuals may have, but I think we've heard from owners, we've heard from farmers, we've heard from actual co-op individuals. I think we've had a fairly representative sample, and sometimes testimony can be rather repeated considering the names or the types of people that are on the list. So I think we've probably had a pretty good sampling of it, and we've also received, I'm sure you've received by email, significant traffic on this particular issue itself. So I'm rather adverse to carrying this over because I think you've had a representative sample. Senator Goggin.
Thank you, Mr. Chair. This is a question for the co-op folks. In regards to the cost recovery, does that dollar amount or what you come up with include power outages, maintenance on your transmission lines, your equipment that's on the system, and does this also include buying back the excess energy that's generated by these solar or wind farms?
Mr. Horan.
Mr. Chair, Senator Goggin, the charge is focused on fixed costs, so some of those costs in terms of the fixed costs, the poles and wires would be included in it, but it does not have any impact on net metering, the retail rate reimbursement of net metering. So no, we're still paying back retail rates to DG developers. That isn't affected at all in this.
Senator Goggin.
Thank you, Mr. Chair. So when you're talking the fixed costs, does that include, like if we have a snowstorm and you lose a power line, does that get reflected back into these recovery costs from the providers?
Mr. Horan.
Mr. Chair, Senator Goggin, not really, no.
Senator Goggin.
So you pick up all that cost yourself and that's not passed on to the consumer?
Mr. Chair, Senator Goggin, yes, that is, yes.
Very charitable, thank you.
Thank you, Senator Goggin. There any amendments from committee members? Seeing none, there's been a roll call requested. Roll call granted. Senator Rosen.
Yeah, thank you, Mr. Chair. I move that Senate File 141 be recommended pass and sent to the Committee on Finance.
Senator Rosen has made the motion to pass the bill and recommend it and pass it to Finance. Further discussion? Hearing none. A roll call being requested. The clerk will take the roll.
Chair Osmek?
Yes.
Vice Chair Matthews?
Yes.
Senator Marty? No. Senator Dibble?
No.
Senator Goggin?
Yes.
Senator Hoffman?
No.
Senator Pratt?
Yes.
Senator Rosen?
Yes.
Senator Senjum? Yes. Senator Simonson?
No.
The total is 6 yes and 4 no. The motion prevails.
On a vote of 6-4, the bill passes and is recommended to the Finance Committee.